Hi, and welcome to today's class, where we will be covering the professional liability of auditors. Due to an increase in the number of investors, the government's reliance on accounting information, and an ever-changing relationship between stockholders and management, there is a responsibility of auditors to safeguard the public interest. Auditors' liability can be found in contract law, common law, and statute law. So what are the factors leading to increased litigation? Well, society as a whole has a greater awareness of litigation and therefore enhanced possibilities and rewards. Audit complexity has also increased with new computerized accounting systems, much more complicated accounting standards, and a context in international business. These audit standards themselves are also more demanding. What is the difference between proportionate liability and joint and several liability? Well, proportionate liability is where damages are paid only in proportion to the court-assessed fault. Whereas with joint and several liability, the plaintiff may recover all the damages from any of the defendants, regardless of their individual share of the liability. And this is an example of this is in the cases of Arthur Andersen, HIH, and Enron. Pressures to reduce the audit time and improve audit efficiency and the expectations gap are factors that have led to increased litigation. We will shortly describe the basic legal concepts. Some of these concepts include breach of contract, negligence, and fraud. What are the potential causes of action against an auditor under a breach of contract? A client may issue a breach of contract proceeding when an auditor fails to perform a contractual duty. Some of the breaches of actions can include that they fail to complete the engagement within an agreed upon time frame, they withdraw from the engagement without sufficient justification, they violate the client confidentiality, or they fail to provide professional quality work. It is then the client or the parties to the contract that can then file suit. What can the court award in the case of breach of contract? Well, they can order the auditor to fulfill the contract. They can issue an injunction, okay? And they can also order the auditor to pay compensatory damages. What are the defences that an auditor might have in successfully defending this breach of contract? They can suggest that the auditing standards were followed, they did not in fact breach the contract, the client was contributory negligent, and the client's losses were not caused by the breach. The next instance that we will discuss is negligence. So negligence may arise through a conduct that is careless or unintentional in nature and entails a breach of any contractual duty or duty of care in tort. To recover damages through this avenue, the plaintiff must prove the following four things. Duty of care was owed, there was a breach of that duty, there is cause, and there were actual damages. And finally, we have common law liability to third parties. As we all know, audited financial reports are used by a number of third parties. Who are they? There are potential investors, there are current shareholders, there are other entities such as banks, lending organisations. So in order to win a claim, a third party needs to establish that a loss is suffered, the loss was due to reliance on the misleading financial report, and the auditor knew or should have known that the report was misleading. What are the auditor's defences? Well, their defences in this matter can be that they were not negligent. They took due diligence and did what a prudent auditor would do. And in fact, the financial report was not materially misstated. It did not cause the plaintiff's loss, and the client was again contributing to the negligence. And finally, there was no duty to the plaintiff. Auditors nowadays need to take upon special actions in order to avoid lawsuits. In addition to establishing good quality controls and quality peer reviews, firms must undertake the following. As we will describe later in the course, they must clearly state their scope of work via an engagement letter. They need to screen their potential clients. They need to evaluate the limitations of taking upon this firm. They need to maintain accurate and complete records and documentation. They need to ensure they have the appropriate insurance in place and a capping of liability, which can be stated within their engagement letters, etc., which limit the liability. These are the questions that you will be required to undertake during class. What are the potential causes of action against an auditor under a breach of contract law suit? What defences might an auditor use if successfully defending a breach of contract lawsuit? And what is the difference between proportionate and joint and several liability? Thank you for your time.